segment, we'll continue to look at Article 1 and its standards of practice. Standard of Practice 1-7 tells realtors that even after our seller client has accepted a purchase offer on her property, we continue to share subsequent offers and counteroffers with the client until the transaction closes. The only exception to this general rule is where the seller tells us she doesn't want to receive or consider other offers. Even where a client waives the right to receive subsequent offers, that waiver must be made in writing. But the fact that subsequent offers must be presented to the seller doesn't mean the listing broker has an ethical duty to continue to actively market the seller's property after an offer has been accepted. There's always a chance a seller who's presented with a subsequent offer may accept the second offer, in effect attempting to sell their property twice to two different buyers. Realtors in this situation recommend that the advice of legal counsel be obtained and seriously considered. While somewhat out of sequence, this is a perfect time to draw your attention to Article 13 for just a minute. Article 13 warns us to avoid engaging in the unauthorized practice of law. More importantly, it tells us that, as realtors, we recommend that an attorney's advice and guidance be obtained when it appears that a party needs legal help. Certainly, a seller who has already accepted an offer to sell her property and is considering accepting a second, different offer would be one situation when a realtor should seriously consider recommending that a lawyer be consulted. Standard of Practice 1-9 deals with the fundamental relationship that exists between a broker and her client. It tells realtors we must respect and preserve any confidential information clients share with us. And our obligation to maintain confidentiality doesn't end when our listing agreement or our buyer representation agreement ends. Rather, the duty to maintain our clients' confidences continues indefinitely. Are there any exceptions to the general duty? Yes. Under certain limited circumstances, a realtor can disclose a client's confidential information. Disclosure is authorized where our client consents to disclosure, where we're required to disclose a client's information by a court of competent jurisdiction, where we know our client intends to commit a crime, and where disclosure of the client's confidential information is necessary to stop the crime from being committed, and where disclosure of confidential information is necessary to defend ourselves or our employees or associates against accusations of wrongful conduct. Standards of Practice 1-10 and 1-11 tell us that when we manage clients' property, we must exercise care for the rights, safety, and health of tenants and others. We must also exercise due diligence and make reasonable efforts to protect clients' property against anything that we as real estate professionals can reasonably foresee. In other words, we act as prudent stewards watching over our clients' property. Turning next to Standards of Practice 1-12 and 1-13, we see that they deal with two sides of the same coin: what we do and what we say when entering into listing agreements, and what we do and say when entering into buyer or tenant representation agreements. When realtors enter listing agreements, we must tell the seller about how we cooperate with other firms and the amounts of compensation we'll offer to other firms for their cooperative services. Realtors also must make sellers aware that buyer and tenant representatives, regardless of who pays them, represent the interest of their own clients. Realtors also disclose to potential seller clients any potential for us to possibly act as a disclosed dual agent. Turning now to buyer and tenant representation agreements, realtors entering into those agreements must discuss with potential buyer clients our policies regarding cooperation. Also, we discuss the compensation, if any, that will be paid to us by our buyer client, the potential for additional or offsetting compensation we might receive from other sources, the possibility that we might, as a buyer or tenant representative, act as a disclosed dual agent. We also discuss and disclose the possibility that sellers or sellers' representatives may not treat our buyer client's purchase offer, including the terms and conditions, as confidential. Put in simpler terms, realtors who intend to represent buyers or sellers take steps to ensure that our potential clients are informed about the important terms of the relationship they are entering into with us. Last, we should touch on Standard of Practice 1-15, which tells listing brokers that when they are asked by a buyer or by a cooperating broker whether there is already an offer on a property, they must disclose the existence of such offers, provided the seller has authorized disclosure of that information. In addition, and where the seller has authorized disclosure of the existence of other offers, the realtor will tell the buyer or the other broker whether existing offers were obtained by the listing licensee, by another licensee in the same firm, or by a cooperating broker in a different firm. Article 1, as interpreted by its various standards of practice, establishes many duties to protect the clients and customers we serve. To be sure that you have a complete understanding of your ethical obligation under Article 1, you will want to carefully read each of the relevant standards of practice. You can also read more about Article 1 in the over 30 explanatory case interpretations you'll find in the Code of Ethics and Arbitration Manual. These cases, which will help you appreciate your promise of professionalism and performance, can also be accessed from the support materials section of the program. Our journey down the pathway to professionalism is just beginning.